Hi, I'm the Strenuous Objector, lawyer and overthinker of pop culture, and I'm here to take a look at your favorite movies and TV shows and ask the question, is that legal? Today, I'd like to call the case of the state versus Christina Yang and Izzy Stevens. Now, for those who haven't seen Grey's Anatomy, it's a TV show that's part soap opera and part medical drama, where all the doctors are sexy, the top of their fields, and yet always seem to have time for relationships and sex in the hospital. In episode 9 of season 1, titled Who's Zooming Who, a man comes in with stomach pains. While draining his stomach of fluid, he dies very suddenly. When Christina and Izzy ask the family if they can perform an autopsy to find out what killed him, though, they refuse, saying they know he died because he was an alcoholic. But being the overzealous interns they are, they decide to do the autopsy anyways without permission. And that brings us to the question for today. Is it legal for doctors to perform an autopsy without the family's consent? As for the relevant law, the show takes place at the fictional Seattle Grace Hospital, which is located in Seattle, Washington. So we'll be using Washington statutes and cases for this discussion. As always, this is not a review of the show. I'm just deciding if what they did was legal. That's it. Now, the first question that comes up is whether a dead person is considered a person or property under the law. That might seem unusual, but the law can be very particular about what things legally are, so it's important for this discussion. In re, or in the matter of, Reinterment of Remains of Faenov is a 2016 Washington Court of Appeals Division I case that discusses who has the say over where a body is buried. In that case, a wife wanted to have her husband buried in Washington state, while the children of the deceased wanted him buried in South Dakota. They presented evidence to show that during his life, he had always wanted to be buried in South Dakota, not Washington. The court ruled that he should be buried where he wanted to be buried while he was alive. But during their analysis and discussion, the court cited a 1927 case, Herzl Congregation versus Robinson, that said there was a quasi-property right in a dead human body inherent in the immediate relatives of the deceased. So while they still decided that the desire of the deceased himself was above the wife, the courts did uphold the idea that there is at least a quasi-property right in human remains. This is important because knowing that there is a property right in a body means that any action against the body would be treated as violations against property, not as a person. That means Bailey was wrong when she labeled the action as assault.
You broke the law! You could be arrested for assault! Do you like jail?
Because assault requires another person, and human remains are quasi-property, and thus no longer a true other person. But wait a minute. Based on Faenov, shouldn't it be clear that without evidence of the wishes of the deceased, the immediate relatives of the deceased get to decide what happens to the body, like in the episode? Well, hold on, because there are two statutes that are very important here. Revised Code of Washington, Section 68.50.10, Coroner's Jurisdiction over Remains, and Revised Code of Washington, Section 68.50.101, Autopsy postmortem, who may authorize. Let's start with Section 68.50.101. In that code section, it lays out the order of priority of who decides what happens to a relative's body. This list goes from the closest relative to the most distant person that can make a decision. That list goes 1. The surviving spouse or state-registered domestic partner. 2. Any child of the decedent who is 18 years of age or older. 3. One of the parents of the decedent. 4. Any adult brother or sister of the decedent. 5. A person who was guardian of the decedent at the time of death. 6. Any other person or agency authorized or under any obligation to dispose of the remains of the decedent. The chief official of any such agency shall designate one or more persons to execute authorizations pursuant to the provisions of this section. What that list means is that when the decision comes between a spouse or a child of the deceased and the doctors, the spouse or child gets to decide whether or not there's an autopsy. Following this statute, it would be clear that the mother, or the daughter since the mother made no real decision, will get to decide if an autopsy is done in this case. But that brings us to section 68.50.10. In that section, the code lays out when the county coroner would have authority over decisions related to human remains. They do that by providing a list of specific circumstances when the coroner, not the family, would have the final say about if an autopsy was necessary. And that, of course, makes sense. One of the times is where the circumstances of death indicate death was caused by unnatural or unlawful means. If a woman died and it appeared that she was murdered, you wouldn't want to leave the decision about an autopsy to her husband, who's either a possible suspect or a grieving spouse. The whole basis for this statute is that there are clearly times when the coroner would be the best judge over the decision for an autopsy. This list includes many examples, such as where death occurs within 1 year following an accident, where death results from a known or suspected abortion, where death apparently results from drowning, lightning, radiation, and the list goes on and on. There are at least 12 different sentences of deaths that would result in the coroner gaining control of the remains. Hidden among the different causes of death, though, is one that's very relevant for this case. Death apparently results from alcoholism. Now, Christina and Izzy may not have known that he was a suspected alcoholic before he died.
Is there something we should know?
I drink a bit.
That's the understatement of the year.
As soon as that fact became known, the King County coroner would have been given the authority to decide if an autopsy was needed in this case, and not the daughter who clearly hated her father. So that means the case is solved. Christina and Izzy are off the hook, right? Well, not so fast. See, the only evidence we have are the facts in the show. And at no point in the show does either Christina or Izzy make any attempt to contact the coroner's office to get their permission. We know this because it's very clear after their talk with Bailey, they didn't have permission.
When's the autopsy?
There isn't going to be an autopsy.
And with the way they go about the autopsy, they clearly believe they are performing an illegal autopsy.
We stole a body. We're body snatchers.
The question then becomes, what criminal law, if any, did they violate? Well, Revised Code of Washington, section 68.50.100, dissection when permitted, autopsy of person under the age of 3 years, specifies the punishment, if any, for unlawful dissecting. It states that every person who shall make, cause, or procure to be made any dissection of a body, except as provided in this section, is guilty of a gross misdemeanor. The exception for them would have been the permission from the coroner, and since they never got that, they are guilty of a gross misdemeanor. But gross as in the very obvious and unacceptable way, and not the very unpleasant, repulsive way. Though some may say they're guilty of both kinds. A gross misdemeanor, by the way, has a maximum sentence of up to 364 days, a $5,000 fine, or both. Something else to keep in mind is that remember when we determined that human remains are treated as quasi-property? Well, that would mean under civil law, the family could also sue Christina and Izzy for any damages they caused to the body. Normally, a medical professional would have immunity from any civil damages caused when determining the cause and manner of death, under Revised Code of Washington, section 68.50.15. But that's again only when the coroner, or family if they have the primary authority, has given permission. But based on the way the family reacted, it's unlikely they would actually sue the doctors, even though the daughter threatened it. In the end, though, after reviewing all the facts and the law, I find that in the case of the state versus Christina Yang and Izzy Stevens, while doctors are able to perform autopsies against the wishes of the family if the apparent cause of death placed the authority with the county coroner, permission to perform said autopsy must be received from the coroner, or at least a designated representative for the office, beforehand. So what Christina and Izzy did was not legal, at least under Washington law. But remember, they would have been perfectly able to perform the autopsy if they had just gotten permission first, instead of asking for forgiveness later. With all that said and done, I'm the Strenuous Objector, and court is adjourned. Now, if you liked the video, hit subscribe and like, and let me know what movie or TV show you want me to research, and maybe your idea will be on the next episode. You can also reach me on social media or keep up to date on future videos at strenuousobjector.com or at Strenuous Objector on Patreon. I keep a list of all the suggestions I've gotten so far and who suggested it, so keep them coming. If an idea gets a lot of interest from others, I'll put it higher on the list for future videos. I'm also planning on getting out some shorter videos where I explain parts of the legal process, starting with criminal law. The first video in that series should be coming out very soon. As always, all the information in the video is for educational and entertainment purposes only, and should not be taken as actual legal advice. If you have a legal question or problem, please contact an attorney near you.